Hi, everyone. Thank you for having me again. And as I say every year, it always feels like I'm home with friends when I'm presenting for Decalogue. What we are going to talk about this year is old rules, new tools, the intersection of the use of artificial intelligence with law practice. And I am more than happy to take questions as they arise during the course of the presentation. If that's all right with Aviva, don't be shy to put your question in the chat. And when I'm at a good stopping point, I'll check it. I think it's really important that we continue to think of the use of AI as old rules, new tools. We are just putting something new onto our practice of law. It does not mean that we have to completely revamp our lives. So what we're going to talk about today is a quick history. How did we get here? The different types of artificial intelligence, the ABA Formal Opinion 512 about the use of generative artificial intelligence tools, and then the concept, which I think I'm going to keep trying to repeat for you, new technology, old rules, and then hot topics. Some of the hot topics right now are agentic AI and what it is, disciplinary opinions and court sanctions that have come down, privilege concerns in the use of AI, attorney-client confidentiality, supervisor and firm responsibility, how do we change our fees, and then the use of AI in legal deserts. So to my theme of old rules, new tools, think back, and I think I talked about this once a couple of years ago when these tools were first coming on the market. When I graduated from law school in 1981, the course on computer legal research was 1 hour in the semester, and it was optional. And what they told us when we learned in that 1 hour how to use legal research on a computer was this is a new tool. It does not supplant your judgment or your thinking or your analysis. There was an article that I read that was published about 10 years ago from a Westlaw employee that talked about the concept of when Westlaw and Lexis first realized that the books were going to go and we were going to be doing everything on computers. And he actually shut his door and said, imagine one day you will be able to do legal research in your office with a printer that is going to print out the research in your office. The concept of the fact that we had to use books and use shepherds with books is completely foreign to today's law students. They laugh when I try to explain to them that when I was in law school, we actually had to run around the library looking for the most recent shepherds, and sometimes people took it to give them an advantage in whatever the legal writing project we were working on was. And then the other thing that doesn't take us that long to think back to is when we first started using email. I think most of us on this call can remember when email first started to be a thing and lawyers were correctly worried about, can I use this new tool? What does it mean when information is stored in the cloud? Can I email my client or do I need to still continue to send them a hard copy? If I email them, can I use Gmail? Is that secure? Do I need a password? And all the kinds of things that we thought about as we moved our practice from paper to technology and email. If you keep those ideas in mind and how we have all adapted over the years, it will serve you well when you think about using AI now. So let's just start to make sure that we're all on the same page. And I'm going to give you some pretty simplistic definitions when these words get thrown around. So machine learning is a good example are the discovery tools And when we say machine learning AI, we mean tools that learn from data that you feed to them. So, for example, if anyone's familiar with the relativity platform to you that gets used for discovery, you give it data, it learns, and then it helps you search that data. Large language models are platforms that use deep learning algorithms to analyze or summarize information. And large language models are very good at drafting things, summarizing things for you, and explaining what it thinks it means. Generative AI is ChatGPT that created all the hilaria a couple years ago. And what generative AI does is it creates content, it predicts, it waits for you to tell it what to do. And remember that generative AI is designed to guess at the answer that it thinks you want it to give, so it is there to please you. The idea of natural language processing is it's the branch of AI that enables computers to understand, interpret, and generate human language, written and spoken. So examples are Siri and Alexa. In my personal opinion, this most recent version of Siri isn't as good as the past version, because if I Siri smiley face, it writes the word smiley face when it used to know that what you wanted was the emoji. So natural language processing changes and it's being updated all the time, just like all these other models. And then last, the one that's sort of been in the forefront of some recent discussions is agentic AI. So agentic AI is built to act. It uses AI agents that generate, perceive, learn, and react, and it creates workflows that run themselves. For example, with your help. So, for example, an agentic AI tool can draft and negotiate a contract. It will orchestrate your workflow. So, an example of that would be Claude Cowork. You give it files and access to the files, and then give it a task to do, and it will write you a detailed response, like, for example, a status update to a client. But it requires very specific and detailed prompts. And remember, all of these tools are only as good as the information that they receive. So here's a question for you. I'm going to just ask a couple questions and then we can see how we compare to a poll that was done by Bloomberg Law. So how often have you used generative AI in the past 6 months for work? Never, a few times a month, once a day, a few times a day, or constantly. So you can just sort of give me a show of hands. How many have never used GAI? Aviva, you might have to help me because it's hard for me to see everyone. Um, how many use it a few times a month? How many use it once a day? Whoops, about once a day. How many use it a few times a day? And how many would say they use it constantly? So for work. So I would say, like, from what I saw, but it's hard for me to see the whole screen, most of us are a few times a month to maybe once a day. And then the next question they asked was, on average, how many times a day, how much time a day do you think it saves you? Whoops. How much time a day do you think using these tools saves you in your daily work tasks? 4 hours, 2 to 4 hours, 1 to 2 hours, 30 minutes to an hour, less than 30 minutes, no time. It looks like a lot of you were saying 30 minutes to an hour to less than 30 minutes. And then how many, I think we already know, rarely use generative AI. There's a number of us that rarely use it. Which best describes your use of agentic AI? Never heard of it before today. Heard of it but have no experience using it. Used it but not professionally, or have used it professionally. Okay, so I see just a few people saying used it and used it professionally. So Bloomberg Law did a survey um, in 2025 on the state of the practice, and they asked lawyers about their use of AI and agentic AI. And so here you can see how maybe you can see how we compared. So generative AI, overall, 31% say they never used it, 31% said a few times a month, 16 said a few times a week, 7 said once a day, 9 said a few times a day, and a very few numbers say they've used it constantly. How much time does it save you? 58% of the people polled said up to an hour a day. And then which of the following best describes your use of it? It looks like many never heard of agentic AI. Some have heard of it but have no experience using it. Some have used it but not professionally. And how many of us believe that AI is growing faster than we can keep up with? I feel like almost everyone thinks that that is true, that it's growing faster than what we can keep up with. Even software people. Bob, I agree. Um, so, and then their survey also asked, I'm trying to minimize this window here for myself. Their survey also asked, do you agree or disagree with each of the following statements? Most lawyers, most tenured lawyers are not as savvy with legal technology. Um, Many people said, I'm trained enough to use it responsibly for legal tasks. I believe a career in law means stability. 56% of the people said AI is growing faster than I can keep up with. 50% said AI will reduce the number of opportunities for graduating law students. And then less than half said it's acceptable to use a personal AI account to help with schoolwork. And then less than half said law school prepared me for the kinds of use of technology in practice. So, and that is something that we're struggling with very much in law school is how are we properly changing or educating our students in the use of AI? So a couple years ago, we started saying that it couldn't be used at all. We're now struggling with the idea that students are using it, regardless of if we say they can, and there is no way to determine if students are using it because none of the mechanisms for checking the use of AI are accurate. So what we're moving towards is trying to make certain that we're still training students to learn how to think and analyze things, and then use the tool in a way that's responsible. And I'll give an example of something that I did in my class that I think would be of interest to everyone regardless. So I have them draft a conflict waiver every semester. And it used to be that they drafted a conflict waiver and they used a template that was available online. This year I said you can use either an online template or you can use generative AI to help you draft a conflict waiver. But I'm telling you now, you need to know what should be in the waiver. We've discussed it in class, and the generative AI tools might not help you. Sure enough, the students that actually used a generative AI tool instead of an established template from a malpractice insurer, or say, for example, Bill Freivogel made more mistakes in their waiver because it included things that had nothing to do with the fact scenario that we were studying. Um, so they learned a lesson, and the lesson was it's not perfect, and you still need to think about what you're doing. And then I guess the next question I would ask is, what ethical principles do you think are impacted by your use of AI? And I think in this audience, I'm guessing everyone knows it's everything: competence, communication, confidentiality, conflicts, and candor. It's all of them. Those are your core duties to your clients. We like to call them the 5 C's. So competence, communication, confidentiality, conflicts, and candor. In 2024, the summer, the ABA issued an opinion on, it's the ABA Standing Committee on Ethics and Professional Responsibility, issued an opinion on the use of generative AI tools and the questions that it raises under the model rules of professional responsibility. How many of you have seen it before? And for some reason, I'm having trouble seeing my audience, Aviva.
Yeah, I can't help you there because I also can't see them since I have this in
I
presentation.
know. So, okay, so I can't see your hands, unfortunately, but if you haven't seen it, it's worth looking at. And it is, some have called it sort of a good guideline for what you need to consider when you're using it. Um, and it tells you in the opinion what I just said, that the use of generative AI impacts competency, confidentiality, client communication, candor to the tribunal, supervisory responsibilities, and fees. And we're going to look at each one of those a little bit. And it recognizes that, and this was in 2024, generative AI tools are a rapidly moving target, which requires continued updated guidance. So think back again. Old rules, new tools. When we moved from paper to electronic, we didn't know if email was secure or not. So we had to learn how to protect confidential client information, right? And we did it. And the opinion from 2024 also recognizes that learning to use AI responsibly is not a static undertaking. And I remember when we wrote it 2 years ago, we knew well that in 6 months, if we got too specific, whatever we put down might have been outdated. So we tried to draft the opinion as sort of a guideline, and it still works. I also have seen that the ARDC has something on their website about considerations for lawyers when using AI. So other helpful guidance that you might be able to find, Bloomberg Law, and it's linked in the PowerPoint that I sent to Viva, has state legal ethics guidance on AI. And it tells you what jurisdictions have issued either advisory ethics opinions, reports and recommendations, or other official guidance. And this is an interactive map, so you can click on the jurisdiction and select on a drop-down bar to see what guidance has been issued in the particular state. So let's start with competence, which is number 1 in the rules. And I think when you think about what does it mean to be a competent lawyer, it is important to remember that to be a competent lawyer includes the legal skills of identifying the problem, knowing the law, knowing the procedure, and how to investigate things. And when you think about it that way, it will help you when you are exploring the use of an AI tool because as a competent lawyer, you already know how to investigate questions in your client's case. So think about it. How do I investigate what this tool is, what it can do for my client, why I should use it, why I should explain to, or how I should explain to my client why I think it is a good thing to use. And there's an Oregon opinion from 2026, and it's talking about chatbots. It's Oregon Ethics Opinion 2026-28. And using chatbots for lawyers on their websites is not a new development. But the ethics opinion discusses the fact that there are many different kinds of chatbots. There are a variety of levels of capabilities that they have. And what you have to evaluate if you want to use a chatbot is how it is trained, how it stores information. You have to do your due diligence on the creator of the platform of the chatbot and the sellers of the chatbot, the vendors, and you have to understand how it responds to questions that you are asking it. And then the other thing is once you use a program, you have to continue in your evaluation of these questions because they are constantly evolving. All the tools are constantly evolving. The most important thing for anyone using an AI tool, and this goes to every single responsibility that you have as a competent lawyer protecting your client's confidentiality, is read the terms of service. Understand what the terms of service are telling you the platform does with information. I have heard, and this is not from personal experience, but I have heard from competent lawyers practicing who use them or test them that the vendors, so the people going to sell you the tool, will always tell you that, oh, it does this, and oh, it protects confidential client information. But sometimes when you actually read the terms of service, you will see that that assurance isn't necessarily accurate based on what the terms of service is telling you. So then there's the issue of how to protect confidential information. Remember, again, the scope of confidential information that needs to be protected is broad. It is all information related to the representation, and you can't reveal it unless your client gives informed consent, the disclosure is impliedly authorized, or the disclosure is permitted or required by paragraph B. How to act competently to preserve confidential information depends on the nature and extent of the risk, and it is very fact dependent. So if you're considering using an AI tool and you are wondering whether it will adequately protect your client's confidential information, one of the things that you have to think about is, how sensitive is the information? What is the likelihood of disclosure of information if you feed it into the platform to train the tool? How much would it cost you to implement the safeguards? How hard is it to implement the safeguards? Will it make representation virtually impossible? So think about it that the the what you have to do to prevent access to the information and how you should consider whether or not to use an AI tool depends. Are you using it to generate ideas? That's a perfectly fine use of any AI tool because typically speaking, you can generate ideas without feeding in any confidential client information. But is it a case involving trade secrets? You probably shouldn't be using an AI tool unless you are darn sure that it will adequately protect confidential client information. And also remember that when you think of protecting client information, we're not talking about publicly used platforms. We're talking about the platforms either that you purchase for use by your law firm or that your firm builds for purposes of your practice, which makes them very expensive. But also think again about what are you using it for? You don't need to tell your client if you're using spell check, right? But again, if it's highly confidential information, you need to be more careful. And then one of the things that the formal opinion 512 talked about is if you are going to use AI for particular work on your client's case, you need the client's informed consent. The opinion explains that it's probably best to put the informed consent in your engagement agreement, and that a form waiver is generally not enough. So what do you have to explain to the client? I use a picture somewhat like this to explain to students that informed consent is a process which involves not nature of the treatment, that's medical literature, but for lawyers, nature of the representation, and then what are the alternatives to using this AI tool? What are the benefits? What are the risks? And give the client a chance to ask you questions before they make a decision, right? But even when you are using an AI tool, the client has to have your best judgment about why you're using that tool, the type of information that will be used in that tool, the type of information that will be disclosed, and whether you are certain or uncertain about its protection. So, for example, I have heard immigration lawyers talk who have built platforms to expedite their handling of clients' cases, which is really important in that area of practice. And they have the conversation with the clients, but they have also concluded that in the platforms they are using, built for their practice, there is a low level chance that client's information will be somehow accessible to a different client or third party. Thus, it justifies the small risk because the benefits are the lawyer can be more uh, uh, can move the cases more quickly and can handle the cases potentially for a smaller fee because some of the more tedious work can be done by the platforms. An example of how you need to be careful about what the terms of service say or the leaking of information is that Microsoft has a program called Copilot, and they were saying that it was useful to help firms do conflict sharing. In fact, in February of this year, Copilot developed a bug that was allowing the AI assistant to summarize emails that were supposed to be screened as confidential, bypassing the data loss prevention policies that organizations were relying on to screen for conflicts. Apparently, they have since fixed the bug, but this is just an example of situations where A, you need to be careful, and B, you need to be constantly updating the information that you have. And again, I feel like we did talk about uh, um, the idea of communication. So again, you need to consult with your client and you need to explain the matter to an extent necessary to permit the client to make informed decisions, remembering that all clients are in a different place with respect to the extent of communication that you need to have with them. So this joke got cut off, but it says something like, well, now we know what not to do. And the other reason, and I think this is completely important, as will be evidenced by the slides we're going to look at in a moment, is why do you have to communicate with your clients? Given the fact that we have seen courts deciding that the client's communication with ChatGPT without the lawyer waived privilege, I would say it is essential now to start reminding your clients that ChatGPT is not your lawyer, you are, and that just like you tell them, don't post your life history on social media, don't ask the publicly available ChatGPT for information. That is why you hired me. So let's look at some recent cases about privilege and work product. The first case, Hepner, came down in February of 2026, and I think that the holding has been sort of misapprehended in some of the articles that I've seen about it. But it's an interesting case, and it should cause us to think carefully. And perhaps this was definitely the case that caused me to think about new communication lawyers must have with their client, reminding them, I'm your lawyer, not ChatGPT. So in this case, Hepner was a criminal defense client, and he input information into a GAI platform that warned that the data, if you looked at the terms of service, it warned that the data could be retained and also disclosed to third parties, specifically the government. And obviously, this United States v. Hepner involves the government. So the court reasoned that the attorney-client relationship applies to, and we know what privilege is, a communication between privileged persons made in confidence for the purpose of obtaining or providing legal advice. And the court said that privilege, this was not a communication with a trusted person, it was a communication with a bot, and there was no expectation of privacy when the client made the disclosure to the platform, and the platform says it does not give legal advice, but so the criteria of privilege didn't apply, and thus privilege was waived by the client's use of that platform. So that is one opinion from one court in the country. I don't think it means that attorney-client privilege is always waived by use of these tools. I do think it means you have to think old rules, new tools. How would privilege be impacted by us using this tool to communicate with our client? So, for example, if it is a tool that your firm has developed and you are working on a client case in your law firm, perhaps there would be a different result. But that's why I'm saying old rules, new tools. Remember what you know about privilege and analyze the use in the context of the platform you are using, what you are doing with it, and what you think your jurisdiction's privilege precedent and or where applicable evidentiary rules would apply. And then the other case that's on this slide, and there's more than one already, this was a work product case from Michigan, said that a pro se plaintiff initiated the use of AI in connection with the uh, with the case, and this court said the pro se plaintiff's use of AI and the tool did not waive work product because they did not disclose the information to an adverse party. Again, these two decisions, they don't alter the doctrine of privilege, they don't alter the doctrine of work product, but they alter and amplify the importance of you understanding the platform, its terms, and its functionality, and having a conversation with your client about their use. So the other way that use of GAI is affected is, or the other thing that it affects is your attorney's fees. And I laugh because probably 30 years ago, Scott Turow wrote an article that said the billable hour must die. And his thinking was that the billable hour was just an opportunity for lawyers to bill more hours in a day bill more hours than there were in a day. And he might get his way now. Why? The rule sets forth a non-exclusive list of criteria that need to be evaluated in determining if a fee is reasonable. So if the AI platform is letting you do your research in less time, you can only bill for the time that you spent using and reading the AI platform. You can't bill for how long that used to take you, with the caveat that perhaps your client doesn't care and wants to agree to you being able to bill them, say, an average of the fees that this type of work would have um, taken you. So if your fee agreement provides for something other than an hourly rate, so an average fee, a flat fee, a project fee, um, your client can agree to that upfront. Um, the other thing to think about in the context of fees is your expenses. So let's say you are developing an AI tool for use in your office. How much of the cost of developing that tool can you bill back to your client? It has to be reasonable, and it typically should be you agreed to in advance by the client. And there's an old opinion that's referred to in the Ethics Opinion 512. It's 93079, and it talks about when lawyers wanted to charge a percentage of the rent back to the client, and tells you that your client could agree to that up front, but otherwise you don't get to charge general overhead back to your client. So I've had people ask me, does the Ethics Opinion 512 stand in the way of the use of technology? Isn't technology supposed to encourage lawyers to be more efficient? And if we're being encouraged to be more efficient, but the ethics opinion says you can't charge for time you don't spend, isn't it standing in the way of efficiency and advancement in the legal profession? The answer is no, it is not. It is just reminding you that your fees have to be reasonable. You can't charge for an hourly rate for time that you didn't use, but there are many other fee structures that lawyers can agree to use when they're negotiating with their client for representation. So, what do the new technologies mean for us? Um, Again, old rules, new tools. So this is from 2023. Colorado lawyer cited fake cases in a motion written with ChatGPT. And the court noted that in a screenshot, when they were investigating this lawyer's conduct, in a screenshot, the lawyer wrote, "I think all my cases cited from ChatGPT are garbage. I can't even find the cases in Lexis." The paralegal asked Crabhill, that was the lawyer, if he had double checked the citations before he filed the motion. "No, like an idiot," Crabhill responded. When asked if he planned to withdraw the motion, Crabhill said he didn't know what to do and couldn't find any case law to support his position, and then added, "I don't have time for this." The final message in his screenshot read, he insisted in the affidavit he didn't know what to do after realizing his mistake. So there you go. what happened was he was sanctioned, and this is 2023. So maybe he should have figured out what to do instead of, and or let's back up. Of course, he should have um, checked the cases before filing the motion. So the question is, are these cases from 2 to 3 years ago still issues of concern? And the answer is yes. So a friend, colleague of mine who works for one of the malpractice insurers that insures a lot of law firms said every time she goes to a law firm and wants to give a talk about hallucinations and checking citations, the associates all raise their eyes and say, yes, we know all this. And she says, well, when I stopped getting calls every day that another filing happened where there were hallucinated cases, I'll stop talking to you about it. So here you go. This was from February 2026, where a judge says, this shows no signs of abating, and ordered lawyers to pay $2,500 over AI hallucinations in a brief. That was one recent post. Another recent post was, I think it's the next one. DOJ leaders have to explain why an attorney used fabricated quotes in a court filing. And it was a show cause hearing, which a lot of these are, where an assisted U.S. attorney filed a response with the court, including fabricated quotations and misstatements of case holdings, and then made false and misleading statements about their origins. And this time, like some courts are starting to do, the court said senior leaders must explain why this happened and how it got by them. Calling it an inadvertent filing of an unfinalized draft didn't work, and those lawyers were sanctioned. So I think, speaking of old rules, new tools, it's a place to stop and talk about hallucinations. In the day of book cases, where we read the cases in a book, you would have read the case before you included it in a motion or brief. You would have checked the responsive pleading of your opponent on the certainly important citations that go to a matter of law that is before the court. You certainly would have read those cases. So the fact that we now have tools available that might give you a list of the cases in short order is not a reason to stop reading the cases, just like you would have done when you started practicing law, and probably like you were taught to do in law school. So to avoid hallucinations, now some people suggest that you can use an AI tool to check for hallucinations of other AI tools. I'm going to suggest that there's no more secure tool than reading it yourself. And I'm going to show you a link at the end of my slides where there's actually at least one example of a lawyer who told the court, well, we use 6 different AI tools to see if this AI tool was hallucinating on cases, and it still failed. And the court said, sorry, read the case, basically, yourself. Don't use an AI tool. So another interesting twist on regarding use of AI tool that's currently been in the news is a case in the Northern District of Illinois. And in this case, the plaintiff, represented by an attorney, settled the case with her disability insurance company. A year later, she asked the attorney to challenge the settlement. The attorney pointed out that it was too late to reopen the case. And then the client, after her attorney told her it was too late to open the case, the client asked ChatGPT if she was being gaslighted by her lawyer. According to the lawsuit that she subsequently filed, ChatGPT told the plaintiff that her attorney had invalidated her feelings and deflected responsibility for her dissatisfaction. The plaintiff fired her attorney and attempted to void the settlement with the help of ChatGPT, eventually resulting what is commonly called a mess. So what happened in that case is the defendant who had settled the case and then got sued by this pro se plaintiff had to answer 45 motions that she used ChatGPT to draft, and they argued that the motions drafted served no legitimate legal or procedural purpose. Delator, that's the plaintiff, has demonstrated a consistent use of ChatGPT through her lawsuits against the defendant Nipon, using it as a means to provide her with legal advice, legal research, and legal papers prepared for the purpose of filing in court. As a layperson with no legal experience, the defendant argues she couldn't have pursued her cause of action or filed the frivolous motions without the legal assistance provided by ChatGPT. So she would have been unable to sustain this campaign of retaliation and harassment in a court, which is now costing them a lot of money to defend. And so they argued that the OpenAI was engaging in the unauthorized practice of law. It is my understanding that at some point after the plaintiff started using it to draft these motions, ChatGPT amended its terms of service to say that it did not give legal advice. I have no opinion on the validity or not of this lawsuit, or if I do, I'm not going to give it. However, know that there's the idea that, oh wait, where did we go? Sorry, we're going back here. There's the idea that ChatGPT is a machine, not a person. Some of the unauthorized practice of law statutes, including the one of Illinois, relate to its use by a person. But the question is, there are multiple causes of action alleged, and I think it will be really interesting to see how this case develops and advances. So it's an interesting case to follow. It's the first case I'm aware of where a defendant actually accused OpenAI of engaging in the unauthorized practice of law, including other causes of action. So that's the DOJ one. There have also been recent cases of judges misusing AI. So federal judges in Mississippi and New Jersey have withdrawn written rulings in a pair of unrelated lawsuits after lawyers in the cases said the rulings contained factual inaccuracies and other serious errors. The Mississippi case, the judge replaced an order that he issued in a civil rights lawsuit after lawyers for the state said in a court filing that it had inaccurate plaintiffs and defendants and included allegations that were not in the complaint. Kind of embarrassing. And on the same day as that happened in New Jersey, a judge withdrew a ruling he issued in a securities lawsuit after defense attorneys told the court that the decision had factual errors and included quotes that were not in the cited cases. A person familiar with it said the research that was produced using artificial intelligence. And then supervisory responsibilities. Remember that if you have an associate using these AI tools, you are responsible for their conduct. That will include an understanding of what tools they are using, what prompts they are using. Some courts, not all courts, and again, old rules, new tools. It depends on where and how it was used and the questions that were asked. Some courts are saying that prompts are discoverable. Some firms have AI use policies. Some firms have gone so far as to block the use of public AI platforms on their work computers. And then if you're an associate, you're bound by the rules of professional conduct, notwithstanding you acted at the direction of another person. So following orders is no excuse. Remember that in the case of fabricated filings, in a lot of the cases, in spite of the fact that there was a supervisor on the file, the supervisee or the younger lawyer is the one that takes the hit. So it's, reputational harm most often to the younger lawyer. And then I want to save some time for questions. So here is, let me just see if I can get it to open. Here is the Damian Charlton. I don't know if you've seen it. The link is on that last slide, and it tracks legal decisions where generative AI produced hallucinated content, but also other types of AI generated arguments. There's to date 1,635 questions, and it gives you the country, and then the decision and what happened. And I also think that you're starting to see some disciplinary cases arising as a result of the use of generative AI. So I'm just wondering, I stopped my share to give a chance for questions if anyone has questions that they wanted to ask that arose either from their use, from attempted use, from building platforms, or any other way that I could help on this topic, or things that you've seen that I haven't covered.
Yeah, I think there's two comments in the chat. They don't seem like questions, but if there's something regarding that you want to respond to.
Okay. Dan's saying, even in the age of bookcases, sometimes just read the head notes. Fair, Dan. That said, I think reading the head notes, as we all know, I mean, sometimes reading the head note works. This is where you have to use your judgment. There's nothing that I can tell you that practicing lawyers don't already know. Sometimes reading the head notes works if it's not a particularly contested factual issue, right? But I mean, one of my favorite opponents who will remain nameless, he was considered the dean of disciplinary law when I was at the ARDC, and he was a regular opponent. He was a personal friend, but he was the master of taking a case that just said one little tweak about what he wanted it to say and using the head note to support his proposition. And then when you read the facts actually helped me. So that is why I say, depending on how important it is, you have to use your own judgment. I totally agree. And I don't know if it's Robert or Bob, it should be common sense, good practice to read the cases to verify they stand for the principled position being asserted. Couldn't agree more. It's somewhat shocking to me how frequent these cases are, because clearly people are filing things without doing that. Like I remember signing my name on pleadings that would get filed with the Illinois Supreme Court, literally being petrified every time I did that something would be wrong, and reading and reading the cases and the sites. Is the use of publicly available AI large language models waiver of the attorney-client privilege if privileged information is entered? Jonathan, that one case from New York says that it is. It was entered by the client. So certainly in that one case, the court said, yes, it was, for the reason that it isn't. So think about again, old rules, new tools, a communication between privileged parties made in confidence for the purpose of obtaining or providing legal advice. If you are using a public tool and putting privileged information in there, it is not a communication in confidence between privileged persons, because it arguably can be seen and or searched by others. And Jody, I kind of agree with this statement. a phony case is not a technology failure, but a supervisory or a competence failure, right? It's a lawyer not doing what they need to do to read the cases. It is amazing because we can all sit here and agree that this is what you need to do, and then by the end of a week from today, bet you anything there's another case in the news that says that somebody else filed a pleading without reading the case, and uh it was a hallucinated content. So any other questions that I can answer?
There's no other questions. If you just want to give us a couple of minutes to bring us to our full hour
Sure.
of some more.
Another thing that you should know is we talked about the rules, but I think that we will see more and more state and federal regulations governing our use of the tools. And we have also seen courts having different certification requirements for people using the tools. So when the hallucination problems first started happening, some judges, especially in federal court and some in state court, were having certification requirements for filing of the pleadings. And I have an example from one from the Northern District of Texas. And in that one, the judge said, all attorneys appearing before the court must file on the docket a certificate attesting either that no portion of the filing was drafted by generative artificial intelligence such as ChatGPT, Harvey AI, or Google Bard, or that any language drafted by GAI was checked for accuracy using print reporters or traditional legal databases by a human being. These platforms are incredibly powerful and have many uses in the law: form divorces, discovery requests, suggested errors in documents, anticipated questions at oral argument. But this judge's certification says legal briefing is not one of them. Here's why. These platforms in their current states are prone to hallucinations and biases. On hallucinations, they make stuff up, even quotes and citations. Another issue is reliability or bias. While attorneys swear an oath to set aside their personal prejudices, biases, and beliefs to faithfully uphold the law and represent their clients, generative AI is the product of programming devised by humans who did not swear to such an oath. As such, these systems hold no allegiance to any client, to the rule of law, or the laws and the Constitution of the United States. And it goes on, but that's just the beginning of that judge's certification. And I will say, about a year and a half ago, using a public ChatGPT platform, we were asking it a hypothetical and it answered, and it assumed that the paralegal was a woman. And when we asked it, well, we didn't tell you, why did you assume the paralegal was a woman? The answer was, everyone knows that paralegals are women. So there's an example of bias in the platforms. So thank you for your attention as always. Thank you all for attending and for inviting me back. That concludes our hour, seeing no more questions.
Thank you, Wendy.
Thank you all.